appeal limited questions of judicial separation on the ground of cruelty. Normally, this court does not go into minute details of evidence. Still, we have considered the evidence. Considered in this context, the allegation made by the respondent in her letter Exhibit 318 cannot revive the original cause of action. These allegations were provoked by the appellant by his persistent and purposeful accusations, repeated times without number, that the respondent was an unsound mind. He snatched every chance and wasted no opportunity to describe her as a mad woman, which, for the purpose of this appeal, we must assume to be wrong and unfounded. He has been denied leave to appeal to this court from the finding of the High Court that his allegation that the respondent was of unsound mind is baseless. He also protested that he was not liable to maintain the respondent. It is difficult in these circumstances to accept the appellant's argument either that the respondent deserted him or that she treated him with cruelty after earlier conduct was condemned by him. It is true that the more serious the original offence, the less grave need be subsequent acts to constitute a revival and a case of cruelty. Very slight fresh evidence is needed to show a resumption of the cruelty, for cruelty of character is bound to show itself in the conduct and behavior, day in, day out, night in, night out. But the conduct of the respondent after condemnation cannot be viewed apart from the conduct of the appellants after condemnation. Condemnation is a conditional forgiveness, but the grant of such forgiveness does not give to the condemning suppose a character to malign the other. If this were so, the condemned suppose will be required duty to submit the cruelty of the other suppose without relief or remedy. The respondent ought not to have described the appellant's parents as wicked. But that perhaps is the only allegation in the letters Exhibit 318, to which exceptions may be taken. We found ourselves unable to rely on the solitary circumstances to allow revival of the condemned cruelty. We therefore hold that respondent was guilty of cruelty, but the appellant condemned it, and the subsequent conduct of the respondent is not such as to amount to a revival of the original cause of action. Accordingly, we dismiss the appeal and direct the appellant to pay the cost of respondent. We all three concur in this judgment. Detailed reasons have been given in this judgment. That's all.